So in this video, you will see a Walgreens security guard who unfortunately shoots someone in the store. Support the channel by liking, commenting, and subscribing. So as you can see in the video, the individual who was shot, who is called Banko Brown. Banko Brown, he was shot by the security guard. But the question is, was the security guard justified in shooting him? And should the security guard have been arrested and have charges pressed against him? Essentially, given that this took place in San Francisco is in the state of California, so California Penal Code applies in this situation. Now, if you look at the video, what you see is, first of all, it was the security guard that tried to prevent Banko Brown from leaving the store, and an altercation ensued. So because Banko Brown had his back turned and had exited the store, the security guard could not claim self-defense, and that appears to be the only legal theory under which he could advance a claim for justifiable homicide. Now, the facts of the case as it stands do not show that Banko Brown had committed any felony whilst inside the store, was going to harm anybody, or was in possession of any weapon at the time. You have to bear in mind that although Banko Brown was suspected of shoplifting in California is usually a misdemeanor, not a felony. So it's a little bit odd that the security guard has not been charged, because there would be enough, under these circumstances, there would be enough to charge him, given the fact that he was an aggressor and the force he used was not proportionate at all. If you look at Section 197 of the California Penal Code, it enumerates several instances under which self-defense could be claimed, such as resisting an attempt on your life. You can certainly advance a self-defense claim there, or because California has the castle doctrine, Section 2 of 197 states, when committed in defense of habitation, property, or person against one who manifestly intends or endeavors by violence or surprise to commit a felony, or against any one who manifestly intends and endeavors in a violent, riotous, or tumultuous manner to enter the habitation of another for the purpose of offering violence. I don't believe that there's any evidence of that from the video that I saw, so I don't think that is an exception that will apply in that case. And then the other instances or exceptions under the law, such as Section 3, which states that there can be self-defense in defending a spouse, parent, child, master, mistress, or servant. It seems as if the code is somewhat antiquated, but basically if you're defending another person. This was not the case here. There were no other people involved. It was just those two individuals. And the last exception under this statute says, when necessarily committed in attempting by lawful ways and means to apprehend any person for any felony committed, or in lawfully suppressing a riot. It's not clear what felony Banko Brown had committed. Again, I will say that. Now, as I said, different facts of the case may arise, but I think the case is pretty much open and shut. So thank you for viewing the video. Make sure to support the channel. You have to certainly share the video, comment, and subscribe.